All right. You ask a question, you get your handful of candy. All right. Who's going to start us off? Over on this side. Already a prize winner. Should I even give him a candy? He's already won something. Now, obviously, Tim had to come all the way around here, so I need the next question to be all the way over there.
Thank you. For the lawyers, there was a bullet in your presentation that said Part 91 Charter.
That's for you.
Can you expound on that a little bit? What was that referring to?
I guess we'd have to review the presentation.
You get two candies because not only did you ask a question, you stumped them.
I think what you're referring to, or what we were referring to, is probably the 91501B alternatives, okay, where, and Jason gave the presentation on that, time-sharing agreements, interchange agreements, parent-subsidiary relationship, those things that 91501B allows a Part 91 operator to do and be compensated for. So that's an exception, relatively narrow exception to the prohibition against a Part 91 operator receiving compensation for providing air transportation. I think that's the only Part 91 charter I can think of. And the charter, I have to say that personally, and again, if we had it on our screen, I'm sorry about that, we shouldn't have, but I don't think the C word should be used in conjunction with Part 91.
I think, those examples we gave as examples of wet leases, but in other parlance, you could call that a charter. It's essentially what it is. But right, you should not use the C word in the Part 91 context.
This is an insurance question. Excuse me, and then I'm a little raspy. I've been sick for the last couple of days. All right. Say we have an airplane that's in maintenance, and it needs to go on a operational check flight with maintenance personnel on board. Is there any paperwork that we could fill out, or we could have the maintenance guy fill out, that if he trips, falls, whatever, while he's in that airplane, he can, while it's on the flight, that he cannot sue Reynolds Jet?
Yes, you can, and it's always good to have that happen. The question in some states is whether that's enforceable or not, and that's a legal question that I really can't address, but I would encourage it as a safety valve. So those contracts absolutely exist.
Okay, thanks.
Yep.
Guys, if you don't ask questions, I have to eat every last one of these before I go home. Oh, good.
Yeah.
I think my question would cover both insurance and legal. The use of contract pilots in a corporate aviation environment always intrigues me. And Scott, I think you mentioned in your presentation that a pilot that works for a corporation that goes to fly for another corporation, the parent company, his primary employer, should have some understanding that he is employed by the other company that he's flying for. And I'm just trying to get a good handle on the liability for the pilot, the primary employer, and then also the hiring company. Because I think the practice, though common, is pretty, a handshake. And so I'm concerned about the legal aspects as well as the insurance ramifications.
You're absolutely correct. It's a handshake done for the most part right now, and there's two sides of it. So I'll look at it from the pilot. If the pilot goes over to the other operation, that pilot should very specifically ask to be included as additional insured and provided a waiver of subrogation on the other owner's aircraft policy. And the reason he should do that is he is not covered under their policy as an insured. So if he's flying that aircraft and he gets sued personally, he is not insured personally. The corporation's insured, he is not. So he's got to be very careful from his liability perspective that he gets added as additional insured. The other thing for the employee, and a lot of corporations will deal with this differently, they'll argue that this person is an independent contractor and should be responsible for his own operation. And that might be the case from a liability perspective, but the other side of it that you have to think about is from a workers' compensation standpoint. The corporation that hires that contract, even though they may have an independent contractor agreement with that person, if that person doesn't buy his own workers' compensation insurance, he's your employee. He's absolutely going to be your employee from a workers' compensation standpoint. One way or another, the state's going to make him your employee. So from the company that's taking the contract pilot on, just assume he's your employee. Even though you have a contract that says he's an independent contractor, he's still your employee from a workers' compensation standpoint. Some companies, and every company is going to handle this differently. Some companies, if I'm the company that's hiring a contract pilot, I might say, you're on your own. I'm not covering you. That's your baby. You're out there for hire. You're making money. You go get your own insurance. Some companies will outright say that. I look at it, if I'm the company's broker, I'd say, look, would you tell your employee that? Just because he's helping you out, why wouldn't you have him in your policy? He's acting as if he's your employee. You're telling him where to go, how to go, when to go, what to go. I mean, you're controlling his operation, essentially. So every company deals with that differently and looks at it differently. So it really depends on the circumstance. So now, the other company that employs this guy on a full-time basis, they're going to want to know, most corporations, they don't want moonlighting going on for this very reason. They try to stop it from happening. But if you're not going to stop it, at least get an acknowledgement. Have your employee go out there and get an acknowledgement from the other company that you're our employee, you're acting as our employee, we insure you under our policies. That way it clearly states if he's operating on their airplane, it's their baby.
Thank you.
I've got kind of a follow-up on contract pilots, if I could, and insurance. Once annually, we submit a list of contract pilots as well as our own information and update the insurance forms for that with our insurer. But it's not that rare that when we actually need a contract pilot, those people that we've put on our list are not available. So we'll ask for we'll find someone, and then we'll ask for an approval on that person to fly that particular flight. But the problem we run into often is the people that are available are people maybe who are in between jobs.
Yep.
And the sticky wicket is the insurer requires that they've had a formal school within the last 12 months. And we're routinely, running into a contract pilot and he's been unemployed for more than a year. So he hasn't been to a formal school with simulator training, et cetera, in say 14 months. Insurer won't allow us to use that contract pilot. Any suggestions?
A number. So what type of aircraft are we talking about, first of all?
It's a midsize corporate jet. Yeah.
Okay. So that becomes less of an issue on any aircraft that can be considered a single pilot aircraft. Obviously, it becomes a much easier solution. The other solution is, again, meeting with your underwriter and talking with them what you're trying to do and what you're trying to accomplish. Your policy, depending on how your policy is written, it might be written as any pilot approved by the named insured. It might have a training requirement, or it might have an open pilot warranty that says, hey, they got to meet X, Y, Z requirements and training. The best thing to do is to sit down with your underwriter and say, look, these are the contract pilots that we want to use. This is what we're typically going to use, but they might be sick or unavailable, so we want the availability and ability to approve XYZ pilot, whatever it may be. Guy's ATP, 2,000 hours, but he may not have school. So the other thing to always do is you might use a contract pilot. Let's pick a Gulfstream 200. You got a Gulfstream 200. He went to training in a Challenger 604. Highlight that he went to the Challenger 604 school. The other thing to actually help the process as well, when you have that situation, always have that person fly with one or two dedicated captains. That's going to make the process much easier with the underwriter. Say, look, he's only going to fly SIC and he's only going to fly with these two pilots. So that's the other way. But the first way is really to sit with your underwriter and say, this is what we want to accomplish. Let's get it done. And do that in a face-to-face meeting. Because, again, it's hard for an underwriter to say no to you, especially when you lay out, hey, I'm only going to hire ATPs. These guys are going to have 3,000 hours total. They're going to have 2,000 hours of turbine time. These guys aren't like kids. I'm not hiring a 200-hour pilot. So that's the way to talk with your underwriter and get it done.
Okay, so you're saying that's something that's negotiable.
It's definitely
not
negotiable.
necessarily a hardcore industry standard.
Underwriters
contract policy.
absolutely want to see school if they can get it. Some underwriters, it is a hard stop, depending on the case. Depending on the insurer, some insurers are hard stop that way. USAIG has gotten that way lately. Sometimes they have a hard stop. Not always, though. They're not always that way. So have the meeting.
Aaron, Jason, I have a question. I know your office is involved with the charter broker rule. Can you give us an update on that and maybe just do a summary of what that is for those that may not know?
Certainly. The charter broker rule is, at this point, it's not yet a rule. It's still a proposal. And this comes under the heading of economic regulation, which emanates from the U.S. Department of Transportation, not from the FAA. What the rulemaking proposal is to allow charter brokers to operate as indirect air carriers or subject to compliance with certain rules. Now, by way of background, under federal law, there are two types of air carriers: direct air carrier, indirect air carrier. A direct air carrier means an entity that physically operates an airplane. So that could be American Airlines, it could be Reynolds Jet, any other 135 operator, any other 121 operator. Those are direct air carriers. They physically operate the airplane. An indirect air carrier is an entity that takes on the same contractual obligation to its customer as a direct air carrier. That is to provide transportation from point A to point B, or if unable to provide it, to refund their money. That's the basic contract of carriage. So an indirect air carrier takes on that same obligation but does not physically operate the airplane. Instead, it hires a direct air carrier to physically operate the airplane. And there are several types of indirect air carriers under federal aeronautical law, and I won't go into them at this moment, except to say that this proposal, if it becomes a regulation, will allow charter brokers to act as indirect air carriers. Okay? At the moment, they can't do that. At the moment, economic regulation of the DOT requires that a charter broker act only as an agent. And the way most charter brokers operate is they act as an agent of the customer, of the charterer. So someone is interested in chartering a Learjet or what have you, okay? They go to a charter broker. They say, hey, I need to go from wherever, Los Angeles to New York next Wednesday. Find me some lift, okay? And that charter broker goes out as the agent of the customer and finds an airplane, okay? And charter brokers bring value to the equation, presumably, otherwise their businesses wouldn't survive. They know the marketplace, they know where to find good rates, et cetera, et cetera. So that's how the great majority of charter brokers operate or are supposed to operate today. It's also possible for the broker to operate as an agent for the air carrier in the opposite way, although that's more unusual. Now, what this rule would do is it would allow charter brokers to act as indirect air carriers, meaning the charter broker could charter the plane for its own account and then turn around and resell the flight as a principal to its customer. And this is a DOT recognition of what, frankly, has been a common practice for a very long time. Because when I said that the charter broker industry is supposed to be operating on an agency basis, I really meant supposed to be operating on an agency basis. There are a heck of a lot of charter brokers out there that haven't gotten the message and that are today operating as indirect air carriers. Only they are unauthorized indirect air carriers because they don't have any sort of license or approval from DOT, which is required to act as an indirect air carrier. So DOT, after all these years, has recognized, hey, this isn't such a bad thing as long as the charter broker complies with certain consumer protection requirements, and that's what we're going to spell out in these regulations. This proposal was put out by DOT a couple of years ago. By the way, going back over the past 10 years or so, plenty of charter brokers have been fined some fairly substantial sums for acting as unauthorized indirect air carriers. We've represented a few of them. And I will say this, if I were one of them and suddenly DOT decides, you know, what we fined you 50 grand for wasn't so bad after all, I'd be pretty upset. But hey, that's neither here nor there. So DOT came through with this proposal, comments were filed, and DOT is close to issuing its final rule that will allow charter brokers to act as indirect air carriers. At least that's what we heard until about 3 weeks ago. And at that point, we were checking in with one of the lawyers at DOT, the one that's most heavily involved in this rulemaking. And he was kind enough to call me and my partner, Gary Garofalo, because he knew we were planning to do an educational session on the new rule at the NBAA convention in Las Vegas in November. And he says, guys, don't plan on making that presentation because that rule's, and he's been telling us all along it would be out by November. He says it's hit a snag of some sort, and you guys better come up with something else for your presentation because it's at best 50-50 that it will be out by November. So something has happened in the final approval process of this regulation. We don't know whether somebody at DOT, in the review process at DOT has an issue. No doubt it's being reviewed at FAA. Somebody over there might have an issue. But right now there's a snag. And when we find out what the snag is, and eventually it'll ooze out, we'll let you know, Al. But at the moment, we're not sure what's going to happen with it. I think it's probably safe to assume that eventually it's going to come out, but it may be quite a while and it may be changed considerably from the proposal.
Thanks, Aaron. Any more? I'll have a basket full of candy here.
I have a question about, if I may, about the...
Get another candy.
Oh, no, thank you. There were the two questions that were asked about contract pilots. Were you guys referring to contract pilots that would fly under Part 91 operations? Yeah. Did you mention in your presentation about that opinion that was issued, the one in the Mississippi one? Okay. Why don't you just...
As Aaron's alluding to, we did mention the NFA interpretation in our presentation. That's pretty much on point. And if it really goes to the contract pilot and their status and cautions the contract pilot that don't assume that whoever is hiring your contract services is the operator of the aircraft with operational control. In fact, FAA, under a case-by-case analysis, very fact-based analysis, could find that the contract pilot, him or herself, is under operational control. So to rectify that, FAA recommends having appropriate agreement in place, a crew service agreement, crew agency agreement, whatever you want to call it, specifically stating that the hiring company has operational control. And if I was advising the contract pilot, I would very much recommend that to limit the pilot's liability. And if I was the as you mentioned as well, if I was the full-time employer of this pilot and he's moonlighting elsewhere, I as that employer, I'd want that confirmation in writing too from the hiring company, so that I'm not found to have operational control by some facts-based analysis. So unlike a lot of questions in FA, on the FAA rules, there isn't clear guidance, but there is actually, in this instance, a very on-point interpretation that we can cite.
I'll just add to that a little bit. To me, what's very interesting about this legal interpretation that was issued, I don't know, a few years ago, I mean, the facts of the situation were that the airplane was owned by a business, happened to be a law firm, and the law firm did not employ any pilots, so they would hire this contract pilot to fly the airplane, a single pilot airplane. And the pilot posed some inquiries to the FAA counsel's office and asked for a legal interpretation. And after their usual 6 to 9 month delay, they got back to him and answered his questions. But one of the things they pointed out was, and he's a commercial pilot, so legally he can obviously be paid for flying an airplane and can accept compensation for flying an airplane. But one of the things they pointed out to him was that in the absence of an agreement with the law firm, with the aircraft owner, that was explicit about the law firm having operational control and him being responsible to the law firm as its agent, to use the term that the FAA uses in that situation. You know, they say either direct employee or agent, but either way, that's your boss. The law firm is your boss when you're flying that airplane. They said in the absence of that, you're engaged in a for-hire commercial air transportation operation, so you personally would need to hold a 135 authorization. You in your personal capacity are acting as an air taxi. So this really shows you how far they go, I think, and it does underscore the importance of having an appropriate agreement in place anytime you're using a contract pilot.
Any more questions? No? Well, thank you, guys. I think we'll wrap it up there. We appreciate these guys, the guys earlier. I'd like to say thank you, a big thanks to Northern Kentucky University. This facility here is a hidden gem in the Cincinnati area. We stumbled across this last year. It's a fantastic facility. I will mention some other bits and pieces on behalf of Tim. You've been seeing the hashtag, the Twitter feed up there, 2015 Seabass. We will continue to use that in the days to come. There will be video and all sorts of other bits and pieces of today being issued in the days to come also. Thank you to Joe and his crew in the box back there. Without their help, all this high-tech stuff, which is beyond me, would not work. I'd like to thank Fred, who was one of the guys helping to serve all the catering outside. He was here last year, wonderful person. I'd like to thank everybody from these seats on up to the back for being here. Thank you guys for showing up. A plug for what's coming up in the Seabass world next year. May Day, so in the spring we want to do another event, not this kind of event, but something a little bit different. Maybe it's a training event, maybe it's what we did the last spring. If you did not attend our May Day thing last spring, you missed out on an enduro karting race here locally, which was a blast. So we did that. We may do a cabin trainer or something. So give us some input as to what you would like to see in the spring. We'll come back here in the fall to do this all over again in 2016. So thank you.